A very warm welcome to my YouTube channel that is Let's Not Long. Myself, Maninderjeet Cr.p.c. Today I'm here to discuss a very important judgment of the Cr.p.c. with you all, and its name is Dr. Mrs. VIJAYA Manohar ARBAT versus Kashi RAJARAM and another. 1987 AIR 1100, 1987 SCR 331. So, there were two parties involved in this case. In the petitioners, there was Dr. Mrs. Vijaya Manohar Arbat, and in the respondents' party, there was Kashi Rao Rajaram Swai and another. This judgment was delivered by the Supreme Court on 18th February 1987, and the bench involved in this judgment was Justice Dutt and Justice MM. There were two judges. Acts and sections. Now I'm going to discuss the acts and sections involved in this judgment. First of all, section 125, subsection 1, clause D of the Cr.p.c. regarding the scope of interpretation of the pronoun his, whether include her. Secondly, section 2Y of Criminal Procedure Code read with section 8 of Indian Penal Code, section 13, subsection 1 of the General Clauses Act, and fourthly, maintenance of father or mother by a daughter, whether her claim by a father under section 125, subsection 1, clause D of the Criminal Procedure Code is maintainable. So these were the acts and section involved in the involved in this judgment. Now I will discuss the facts in issues. That is, which were the main issues involved in this judgment. First of all, as we all know, this judgment deals with section 125 of the Cr.p.c. that is related to the maintenance. In this case, the maintenance of the parents by a daughter, whether married or unmarried, is discussed or decided by the Supreme Court. So the first fact in issue was whether under section 125 subsection 1 clause D of the Cr.p.c. has imposed a liability on both the son and the daughter to maintain their father or mother who is unable to maintain himself or herself. Second issue is whether married daughter is liable to maintenance to her parents if she has sufficient means. And third was whether under section 125 Cr.p.c. the word he could be denoted as she. So now I'm going to discuss the facts of this case with you all. First of all, the appellant, a medical practitioner at Kalyan, District Thane, is the married daughter of respondent number 1, Kashirao Raja Ram Swai, by his first wife, who died in 1948. Thereafter, respondent number 1 remarried and he is living with his second wife. That means the father of the doctor, lady doctor, remarried and now was living with his second wife at the time of the petition, at the time of the appeal. He filed an application before the judicial magistrate, first class Kalyan, claiming maintenance from the appellant at the rate of rupees 500 per month on the ground that he was unable to maintain himself. A preliminary objection raised to the effect that an application under section 125 subsection 1 clause D Criminal Procedure Code by a father to claim maintenance from his daughter was not maintainable was overruled by the trial magistrate. Secondly, in the next step, it was upheld by the High Court in revision. In the further step, the daughter filed an appeal by special leave in the Supreme Court. Now, the Supreme Court, it was up to the Supreme Court. Now, the Supreme Court dismissed this appeal and held an application under Section 125, subsection 1, Clause D of the Code of Criminal Procedure 1973 by a father claiming maintenance from his married daughter is perfectly maintainable. Secondly, Section 125, subsection 1, Clause D of the Code has imposed a liability on both the son and the daughter to maintain their father or mother who is unable to maintain himself or herself. Further, the Supreme Court held that the object of Section 125 Criminal Procedure Code is to provide a summary remedy to save dependents from destitution and vagrancy and thus to serve a social purpose. There can be no doubt that it is a moral obligation of a son or a daughter to maintain his or her parents. It is not desirable that even though a son or a daughter has sufficient means, his or her parents would starve. Apart from any law, the Indian society casts a duty on the children of a person to maintain their parents if they are not in a position to maintain themselves. It is also their duty to look after their parents when they become old and infirm. Further, the Supreme Court has referred to the case named Bhagwan Dutt versus Kamla Devi, that is of 1975 SCC 386, and held that it is true that Clause D has used the expression his father or mother, but the use of the word his does not exclude the parents claiming maintenance from their daughter. Section 2Y of the Criminal Procedure Code provides that words and expressions used herein and not defined but defined in the Indian Penal Code have the meanings respectively assigned to them in that code. Further, Supreme Court held that Section 8 of the Indian Penal Code lays down that the pronoun he and its derivatives are used for any person, whether male or female. Thus, in view of Section 8 of the Indian Penal Code, read with Section 2Y of the Criminal Procedure Code, the pronoun his in Clause D of Section 125, subsection 1, Criminal Procedure Code also indicates a female. Further, the Supreme Court held that Section 13, subsection 1 of the General Clauses Act lays down that in all central acts and regulations, unless there is anything repugnant in the subject or context, words importing the masculine gender shall be taken to include females. Therefore, the pronoun his as used in Clause D of Section 125, subsection 1 of the Criminal Procedure Code includes both a male and a female. Next, the Supreme Court also held that, in other words, the parents will be entitled to claim maintenance against their daughter provided, however, the other conditions are, as mentioned in the sections, are fulfilled. Supreme Court further held that before ordering maintenance in favor of a father or a mother against their married daughter, the court must be satisfied that the daughter has sufficient means of her own independently of the means or income of her husband, and that the father or the mother, as case may be, is unable to maintain himself or herself. Further, the Supreme Court held the expression his father or mother is not confined only to the father or mother of the son, but also to the father or mother of the daughter. In other words, the expression his father or mother should also be construed as her father or mother. A daughter after her marriage does not cease to be a daughter of the father or mother. If it is so, parents having no son but only daughters and unable to maintain themselves would go destitute if the daughters, even though they have sufficient means, refuse to maintain their parents. So this was the judgment related to the 125 of the CRPC, that is maintenance, and it was related to the maintenance of the parents by the married daughter. So the Supreme Court very beautifully interpret the word he, which was included in section 125, also include the word she. So it make obligation of the parents, it make obligation of the son and daughter to maintain his or her parents. So at the end, I just want to say, if you like my videos and like this knowledge, please like and subscribe my channel and share as much as you can. And this is Let's Know Law with Maninder Jeet Kaur Poparai, and thank you so much.